Warringah.
Thank you, Madam Deputy Speaker. I rise today to speak on the Federal Circuit Court and Family Court of Australia Bill 2020 and the associated consequential amendments bill. These bills seek to unify the administrative structure of the Family Court of Australia and the Federal Circuit Court of Australia to create a Federal Circuit and Family Court of Australia comprised of Division 1, which will be a continuation of the Family Court, and Division 2, which will be a continuation of the Federal Circuit Court. Much has been said in this place about these legislations, and there's nothing really particularly good that can be said about this legislation. It's a merger of two overstretched courts without substantial additional resources to support them. It can't even be described as a band-aid because I don't think it even counts as a band-aid. I strongly oppose this merger. The courts are overrun, judges are overwhelmed, many taking mental health leave and some physically collapsing. Those who leave are often not replaced. We have parties distressed attending the courts, seeking an early resolution of issues that go to the heart of their sense of self, of their family unit, of their relationship with their children or their ability to house themselves and meet their bills. And they're often told they have to wait months to get before a judicial officer. And instead of actually listening to that, listening to the experts and implementing some changes and amendments that would actually help the system, this legislation really is not going to address any of that. The Senate Legal and Constitutional Affairs Legislation Committee supported the implementation of this bill, and in response to that, there was a highly bipartisan approach. The President of the Law Council of Australia said the report on the merger by government senators is entirely unsatisfactory because it does not engage in any meaningful way with the concerns raised by more than 110 stakeholders who work in the family law system and witness daily the impacts on children. The family law and legal community more broadly are united in their doubt that these changes will achieve their stated objective. The Attorney-General's Department explained in the legislation's primary purpose is to improve justice outcomes for Australian families and make the federal law courts simpler, easier for families to access. But the Law Council, the Australian Women Against Violence Alliance, Queensland Law Society, Community Public Sector Union, Community Legal Centres Australia and the New South Wales Bar Association, amongst so many others, questioned whether these bills would achieve these objectives. The National Aboriginal and Torres Strait Islander Legal Services instead indicated the bills would not address the problems, delays and inefficiencies in the family law system and should be rejected. The argument has been mostly, it appears, based on a 6-week desktop review of potential efficiencies conducted by PwC. Is this really what it's come down to? The potential efficiencies that will impact the lives of so many people that come that have to engage with the family law system. Their distress, their absolute emotional distress is being brought down to the potential efficiencies by some pen pushers at PwC. In 2018, the authors of the report, they appeared before the Senate committee and they claimed efficiencies were dismantled. Well, their claimed deficiencies were absolutely dismantled by the Senate committee questions. Even the authors of the report ultimately walked away from the numbers. The desktop review lasted only 6 weeks, didn't interview any lawyers or families with experience of the family court system, and the headline efficiencies are not supported by evidence and did not result from meaningful engagement with those who know and use the system. The principle of a single point of entry is something that is worthy of discussion, but many have argued that that's not necessarily what's going to be achieved with this bill. And the price of a single point of entry at the expense of losing the specialisation of the family court is actually just absolutely the wrong direction. The court's annual report shows that the current caseload is just unbelievably stretched. And I must say, before joining this place as a family law barrister, I experienced firsthand that caseload. I know what it's like to turn up to court with a client and wait for hours, and a judge completely overwhelmed by their caseload and the numbers of files before them simply tell clients that they're very sorry, but they will have to come back in often 2 to 3 months' time. Their issues completely unresolved. There was additional funding provided in this year's budget, but the funding won't translate into a meaningful reduction in strain on the system unless we make meaningful amendments to the system. And in fact, these bills will exacerbate the problem. In the Family Court's 2019-2020 annual report, 21,054 applications were filed in 2019 and 20, which was the highest filings in 5 years. The Family Court's annual report confirmed that there continues to be a backlog of more than a year's worth of cases, with more final orders applications pending at the close of this year than were finalised within the financial year. The wait is getting longer. The Federal Circuit Court disposed of 62% of final order applications within 12 months, falling significantly short of its target of 90% for the second year in a row. The Family Court warned that the impacts of COVID-19 will continue to be felt by the system, litigants and judges in the year to come. Hearings that have been scheduled for months in advance to occur in 2020 are now being cancelled by email and rescheduled, with some final hearing dates now not being available until 2022. Just stop for a moment and think about that. That a party going to court to assist with resolving an incredibly sensitive issue is being told they will wait 2 more years before even getting a chance to argue their case. Proceeding with the amended merger bill at a time when the Federal Circuit Court is already struggling through chronic under-resourcing and underfunding to manage its family law load, alongside a crushing and growing migration workload, is reckless, and it will put both litigants and judges at significant risk. The Productivity Commission 2020 report on government services revealed that between 2012 and the close of 2019, the backlog of all pending non-appeal applications in the Family Court grew by 34%, while the backlog of all pending applications in the Federal Circuit Court grew by 63%. The Law Council has argued that while the increased legal assistance funding provided by the National Legal Assistance Partnership, announced in June this year, is certainly welcome, the funding contained in this year's budget is insufficient to address the significant unmet need in the system, and the courts and a one-off injection cannot rectify a decade of chronic under-resourcing. We need to be clear what COVID-19 has done to this system. The number of urgent applications filed over just 4 weeks in March and April alone increased by 39% in the Family Court and 23% in the Federal Circuit Court. The courts told the merger inquiry hearing on the 6th of November that during the COVID-19 pandemic, urgent family law applications filing had increased by 142% in the Family Court and 63% in the Federal Circuit Court. As of 6th of November 2020, 2 in 3 Federal Circuit Court judges have more than 300 matters in their dockets. 27 judges have more than 400 cases in their dockets, and 5 judges have more than 500. 1 judge has 659 cases. In the Family Court, 2/3 of judges have more than 300 cases on their dockets, and 5 judges have more than 500 cases. So to put this into perspective, the 2017 House inquiry into the better family law system recommended reducing docket sizes to something like 100 cases per judge to significantly reduce delays. So that means we need a significant increase in the number of judicial appointments. What we really need from the government is to increase the number of appointments, the number of judge positions available. It's not about just filling vacancies, because we know the existing number of positions is inadequate. The former Justice of the Family Court, Elizabeth Evatt AC, has warned that the proposed merger of the Family Court and the Federal Circuit Court is likely to undermine the integrity of the Family Court and lead to undesirable outcomes for the parties. It's inconsistent with the original aims of the Family Court, which was established as a specialist court. Increasing the number of cases in which issues of family violence, child abuse are raised, there's an even greater need today for family law jurisdiction to be vested exclusively in specialised judges who do not exercise any unrelated jurisdiction. The second Chief Justice of the Family Court, the Honorary Alastair Nicholson, AO RFDQC, said that passage of the Family Law Act in 1975 and the setting up of the Family Court were some of the most significant social legislation ever to be passed by the federal parliament. We should be proud of that instead of trying to dismantle it. What those proposing this merger do not seem to understand is that family law is complex and nuanced. It's not to be judged by the output of the number of cases as if the courts are sausage machines. Through input is important, but so is the quality of the decisions made. Judges need to be able to have time to assess all the facts. Parties deserve their case to be heard in proper, timely way with appropriate assistance to the courts. Cases can be extremely complex and require specialist knowledge of the type that has always been available in the family court, which has provided leadership in the proper interpretation and principles to be applied by other courts with family law jurisdiction. We're actually the envy of so many other countries. The family court is a court that's been envied throughout the common law world, and its judgments have often been cited with approval by the courts of many other countries like New Zealand, the UK, Canada, the USA and others. So its significance as the only specialist family court set up as a superior court of record, and particularly that of its appeal division, cannot be overemphasised. The former justices have joined more than 110 stakeholders on the front line, urging the Parliament to vote against this merger bill, scrap it, and go back and come back with some good legislation. This merger will only increase costs, delay and stress for families. The Family Court and the Federal Circuit Court is a really distressing place. I've appeared as a counsel for both mothers and fathers. I can't begin to convey the distress parties experience of being told that will take months from filing to get before a judge for a decision. The practical aspect that this means, it means a party might go without contact with their child for an extended period of time until allegations can be properly heard and assessed. It means a party may remain in serious financial difficulty, may even find themselves homeless until their case can properly be assessed. That's not acceptable, and this bill doesn't remedy this at all. These issues impact every electorate. In Warringah, we are the same. The family in court, the problems of the family law system reach everywhere. A domestic violence pop-up shelter in March was set up with the onset of COVID-19. That shelter is housing 70 women and children that would otherwise be suffering or homeless. The Family Law and Federal Circuit Court are dealing with complex issues, and they require the support of more specialised counselling services, but also specialised courts to deal with the issues. The Family Court is the only court that can support such complexity, and it needs to be staffed with specialists qualified to deal with the issues at the highest possible standard of care. The Australian Law Reform Commission in May 2017 made a number of recommendations. The report was delivered on March 2019 and included 60 recommendations which would go a long way towards addressing the reform required in the family law system. Yet the government has still not responded to the ALRC recommendations that would improve the family law system. This merger was outside the scope of the inquiry, but we still have silence from the government on the ALRC recommendations. That's not acceptable. We've heard from so many parties during the family law inquiry that I've been part of this year, of parties who have been let down by the system. If we generally want to address the problems, we must start with the recommendations of the ALRC. The Law Council President, Pauline Wright, said that no amendment to the bill can cure what remains a flawed and dangerous proposal without evidentiary foundation. There is no doubt we need reform in the family law system, but the merger is the wrong move. Lawyers, judges and families are united in their opposition. We need to help the courts better service distressed families. We need specialisation of professionals, and we need to make sure that it's properly resourced and funded. We need more legal aid in the system so both parties to disputes can have access to assistance. We need more counselling for men and women. We need more funding for specialist judges and experts. So I urge the government, please, this is a system that is a highly distressing court system. People, Australians, everyday Australians, are impacted by what happens in the family law system, and it actually needs a proper proper structural assistance, not a merger and a shortcut. Thank you.